All right, hello, welcome to everybody. Thanks for joining us today for this Business Rescue webinar. It's going to be an insightful discussion. We have George Nell, Senior Business Rescue Practitioner, and Lizelle Acker joining us. George is an admitted attorney with over 34 years of experience. He has a master's degree in cross-border insolvency law. As a Senior Business Rescue Practitioner and a liquidator, George has successfully managed over 160 business rescue matters. His expertise have been pivotal in rescuing more than 65 companies at this point and safeguarding over 4,000 employees. George's practical approach to business rescue and liquidation, combined with his extensive legal background, has earned him a reputation as a trusted advisor to both private and public sector clients. So thank you, George, for joining us today. We really appreciate it, and we're excited to hear from you. Next, we also have Lizelle Acker with us. And Lizelle is an accomplished advocate with extensive experience in commercial litigation, business rescue, insolvency law. Lizelle's distinguished career has seen her provide expert legal counsel to a wide variety of clients, including financial institutions, business rescue practitioners, and major corporations across various industries. Lizelle has been appointed by the High Court and Master of the High Court to act as Commissioner in numerous insolvency inquiries. And she also plays a significant role in the legal community as a national board member of the South African Restructuring and Insolvency Practitioners, SARIPA, and is an active member of Insol International. Lizelle regularly shares her valuable insights at SARIPA seminars and workshops, contributing to the advancement of best practices in restructuring and insolvency. So thank you to both yourself and George for joining us today. I've just got
Brandon.
some housekeeping.
Hello, everyone.
So questions, if you have any questions throughout the webinar, please just put them in the chat and we'll get to them. I will raise your questions with the speakers, and this session is being recorded, so please be aware of that. If you have any objections there too, or you want to stay anonymous, then I'm concerned, but just keep that in mind. All right, thanks. Off to you, George, to kick us off.
Thank you, Brandon. It's a pleasure to be here. Brandon did some of his articles with my firm way back, and now he's grown a moustache. So he's definitely now a senior lawyer. And I've been invited by himself to join you this afternoon. It's a fantastic opportunity to talk to the hand-picked persons from the firm that Brandon represents. So since the inception of the legislation on the 1st of May 2011, there's certain interesting statistics that accrued over the years. And we've recently gotten hold of a document prepared by the CIPC at the lecture that we gave in regard to business rescues. And that this as updated as at the end of August 2024, and I would like to take you through the quick stats. Lizelle and myself will talk to the document in front that's been screen shared and the slides, and then we will carry on with the questions from Brandon. If you can screen share the first slide, Brandon. It's just a bit out of focus, sir.
How does it look, George? Can you see?
No, it's out of focus.
Out of focus?
Yes, heavily so.
Okay, that's interesting.
Brandon, I'm happy to share it.
If you don't mind, please, Lizelle.
Not at all. Would you I've got just quickly send that one to me as well, so that I'll make sure that I've got the right one. Thanks.
Brandon Zandri is also in the room. She can share it. She's sitting with me in the room, so if she's allowed to screen share, she can quickly do that.
Sure, thanks, George.
Zandri, can you screen share? Just allow Zandri to also be an admin and screen share the document.
Yeah, no problem, George. On it for you.
Okay, while Brandon is sorting that out, it's an interesting world we live in. I was issued with a license to become a senior business rescue practitioner on the 24th of August 2011, and took our first appointment at that stage. At that stage, no court rulings were made in regard to business rescue. No precedents were available of any letters to write to directors and the like. And it was really us looking at the insolvency, law of insolvency, and what we did in liquidations, and as lawyers to work out the path in business rescues. And since then, we've come 13 years till the 24th of August this year, and it's developed tremendously. There's now approximately 450 business rescue practitioners registered at the CIPC, and it's now a real profession. If you can screen share that, Sandri. Brandon, we still have no access to screen share.
That's right. I think, Lizelle, would you mind sharing it with us?
She haven't got it with her.
No, sure, I've got it. Let me do that. No problem.
Okay.
Give me a sec.
Okay, there we go. Initial jitters are behind us, so let's carry on with the show. If you can go to slide number 4, Lizelle, so slide number 4 is just the licensing of business rescue practitioners. Very interesting reading. Is that during slide number 4, if you can just stay there, Lizelle.
Sorry,
there it is. Yeah, thank you. It's testing to be on TV, ladies and gentlemen. So it's the production is now on its way, and we won't have any interruptions anymore. So if we can talk to this, in the first year there was only 19 business rescue practitioners licensed, whereof I was one of them. Then the second year, 38 were licensed, and then it was a flat line between 2013, 14, and 15. And then all of a sudden in 2016, there was more than 33 business rescue practitioners licensed. And you will see when we get to the slide, that correlates with the upbeat and upswing in business rescues, specifically in 2016. Just after COVID started, everybody was looking for something to do, and then in that year there was 111 registrations of business rescue practitioners or license being issued by the CIPC, and now it's dwindled down to 75 people that was registered in 2024. If you can go to the next slide, Lizelle.
Yeah.
Okay, so the areas in South Africa that is most prominent is Gauteng area. 28% of the South African population resides in Gauteng, even though it's the smallest province. It's the gross domestic product of Gauteng is the highest of the whole country, and you will see that it is then Western Cape, closely followed by KwaZulu-Natal, and then the Free State, Eastern Cape. But for instance, there's no business rescue practitioners registered in the Northern Cape. Limpopo has only got 4. In Mpumalanga, we serve from Gauteng. We support and serve Limpopo province, Mpumalanga, and Northwest province. I see there's no figure at Northwest. I don't even put their figure, but we do work in Limpopo, Mpumalanga, and Northwest. Cape Town, and if we've got a national business rescue, we will do the work all over the country. But that is the situation at present. Next slide, please, Lizelle. I am so glad that I've got an advocate to put up the slides. Maybe you can talk to this one, Lizelle.
If all else fails, then I can become your assistant, George. So, George, as we were going through this one for me is very interesting, and in particular in the context of a discussion that we had at a recent summit on Monday for Business Rescue Summit, is one of the key points that was raised is what expertise are needed for someone to be a business rescue practitioner. I think the consensus was that it depends on the nature of the actual business and the rescue. But what interests me on this is that by far the majority of people have some form of qualification or management rather than legal and accounting. I always thought that the accountants are the ones who actually are the most suited, simply because of the actual restructuring. Legal is an interesting one, and I think that might be because of the insolvency background to it. But I think it's really a promising and positive sign of what is expected to be restructuring a business, where it's someone with the expertise to run a business, and that's a very positive slide for me to see. It looks like we are moving in the right direction, at least.
I've got a little bit of a contrary view because I'm a lawyer. I think all practitioners should be lawyers, but I've written an article about being a business rescue practitioner. At least you have to have legal qualifications and knowledge, accounting knowledge, liquidation knowledge, and over and above everything else, you have to be a good politician. But that will come out in later submissions that I've got to make. And next slide, please, Lizelle. Yes, then Lizelle will talk about the split between females and males, but there's 31% of the practitioners are senior business rescue practitioners, 54% are junior business rescue practitioners, and 15% are experienced business rescue practitioners. The difference between the different business rescue practitioners and it's small, medium, and large companies. A small company's public interest score is between 1 and below 100. From 100 to 500, it's a medium company, and above 500 in state-owned companies is a large company. That is now public interest score is calculated on turnover, employees, and exposure to outside companies, to outside creditors, and then also to the shareholders must be added to that. And that's how you calculate the public interest score. Lizelle, if you got something to say about the female-male split?
I will not be wearing my feminist hat this evening, although I've said my say about this more than once. What is for me encouraging, George, is the juniors. There was a time, and still I think in the insolvency and business rescue space, where it is so important to have continuity. And it's the juniors. And when we say juniors, I mean it's not necessarily in terms of age. You've explained that, but it is truly a manner of getting through the ranks, so to speak. Start at the bottom, restructure smaller entities, and build your way up. By no means I suggest that the issues are less in a small company, but it is, I mean, it's certainly more complex in larger companies. And the moment that juniors get involved in, as you will know, George, more often than not, we have people taking joint appointments, which is then where the juniors most and foremost do the groundwork, I would imagine, running around on the operational side, which is exactly where you need someone to learn the ropes.
Now, just for clarity, if you're a junior, you can take a senior appointment, but then you have to take it with a senior business rescue practitioner.
Agreed.
So it's not non-accessible, but you have to have a senior practitioner involved. You can have the next slide, please, Lizelle. So that is per province. Again, white male are dominating in the provinces. Let's see, the green is now Gauteng, and then the color coding is Free State, Northern Cape, Western Cape was the grey. It correlates with the previous slide. Again, they say there's no colored male involvement. That is not 100% true. I know of at least 2 or 3 business rescue practitioners that's friends of mine that is mentioned as colored people. So that is the situation at present. We need some empowerment. We need some mentorships. Ourselves are having a mentorship program since COVID, where we put about 15 to 25 people through a mentorship program, and the CIPC has recently introduced some document which indicates that only tertiary qualified people with a relevant qualification can be licensed as a business rescue practitioner. We have sent that to you, Lizelle. You can maybe, when you're ready, screen share. That's not necessary now, but you can go then now to the next slide, if you don't mind. Okay, there's the professional bodies. Again, LPC, SARIPA, and SAICA is the most prominent bodies. TMA is also there, and the rest of the bodies, some of them are known to us, and some of them are very, very small. ACCA, I see they've 1 member, if I read correctly there. I don't know who that is. So but the majority of people join SARIPA and the TMA as management business qualified people with MBA, BCom, business management, and things like that. The people that have got legal qualifications as lawyers, they usually join the LPC, and the chartered accountants usually join SAICA. I'm a member of the LPC, TMA, and SARIPA, and there's a place for each of those organizations, whereof TMA and SARIPA are more prominent in the business rescue fraternity and do serve their members. And not that I say that the rest of the accredited organizations doesn't serve their members properly, but they are very focused on business rescues specifically, and we're talking about business rescues. Maybe you can, if you want to say something about this, Lizelle.
No, I'm going to. Otherwise, we might run out of trouble, out of time. I'll keep my thoughts for the meaty discussions on this.
Yes. Okay.
I think this is it for. Sorry, let me just have a look.
Just the one about the sectors. Maybe we can just have the slide about the sectors. Don't know which slide it is.
Here we go.
Maybe yes, the one before that one, number 12, is also an interesting one. Ladies and gentlemen, yes, this is now. As I said to you, that there was an influx of business rescue practitioners in 2016. So you can see there was 481 or 51 business rescues in that year. That was a record year. Up to date, there's only that was till the end of June 2024. There's only 122 business rescue matters. If you extrapolate that, that will be the lowest year. It will be 244 matters till the end of the year. It will be the lowest year in business rescue appointments. And then the next slide is the sectors that it is in. the different sectors are listed here. We will look at those quickly. And you can see, if you're now an economist and also an analyst, the slide shows which of the sectors are struggling the most. It's just a little bit small on my page, Lizelle.
Let me just see, George. It's the strangest thing. Let me just do this, and then we can.
I think that is okay. We can carry on. Otherwise, we're going to run out of time, as you said. So, Brandon, over to you. That is our submissions in regard to that.
Oh, thank you, George. I appreciate that. It sets a nice background. I do wonder, it feels strange to me that we've seen such a decline, or if you extrapolate that figure for this year, it may be the lowest yet. And I wonder if more creditors, if it doesn't speak to creditors perhaps turning back to liquidation in a sense. But again, I don't have the figures on that. It just strikes me as interesting. But yeah, George, you said you've as we know, you've been involved in business rescue for a long time, since inception, just about after 2011 or during 2011. And the first question I have for you is, from that time, and perhaps from even from your first appointment up until to date, what is your view on creditor sentiment on business rescue proceedings? In my view, or from my understanding, is sentiment was a bit negative towards business rescue back in 2011, and I want to know whether that's gotten better or not, in a sense.
Well, my wish list is that the sentiment of creditors is very high towards business rescue, but in reality, initially the sentiment was low because there was not a lot of knowledge about the business rescue fraternity. The business rescue practitioners didn't know what they were doing, and was feeling their way in the dark. As it developed over the period of 13 odd years, there's a lot of SCA judgments and things like that. But the fact of the matter is there's now internationally a turn back to turnarounds, informal turnarounds, not specifically liquidations, but we had a submission by the World Bank on Monday at that summit, Business Rescue Summit, that's RIPA hosted, that the stats are that it is turn back to informal turnaround. So it will dwindle between liquidations, business rescue, and informal turnarounds. And that will take the flavor of the month, or the flavor of the year will take a prominent place. But my view is that there is a place for business rescue. The stats that you read was that we have been involved in 65 positive outcomes. That was before we have changed the figure of 130 to 160. So the stats is approximately 60% success rate if you choose your business rescues good, and some of that success rate is a trade-out scenario and also a sell-out scenario. So I would say that 30% of the entities that you take on as a business rescue practitioner could be, in the sense of the word, a trade-out scenario could be accomplished, and the other 30% of the 60% that I now refer to is the sell-out scenario, and that's the same, a better dividend than in immediate liquidation of. In the general terms, we would say that the 30% is what we're looking at. We're looking at selling, saving businesses and not just selling off assets. But the 30% rate is not too bad because it saves 30% jobs that would have gone into liquidation and things like that. So the sentiment of the creditors are not so positive at this stage. I would say on the lower end of the 50% scale, but they realize that there is a place for business rescue practitioners and business rescues. Thank you, Brandon.
Okay. Thanks, George. I appreciate that. And then perhaps just over to you on the same question, Lizelle, particularly your clients. What's the view from that side? Is business rescue still dominated by legal challenges, or have you seen an uptake in creditor sentiment, or perhaps the inverse of that even?
Brandon, for me, the legal questions have certainly evolved and has become more complex and nuanced. What I mean by that is in the early years, of course, we had to litigate on the interpretation, and we litigated simply on understanding what the legislator meant and how the process worked. That is certainly, when I say crystallized, we have a very good understanding and solid base for what it means for a company to be in business rescue. I think the litigation part has matured, which also brings with that some maturity in creditors and situations where there are less nuanced and complex disputes. That being said, I think the stigma is unfortunately still there in relation to business rescue. Whatever the reason for that is, we can debate for how long ever we want to. There is still a stigma. It is unfortunate. That being said, your key role players, your major lenders, your trade unions, all of that, although they are still sometimes maybe a little bit aggressive and there's acrimony, there is participation and communication, which I think has come a long way in where we were 13 years ago.
All right, all in all, quite positive. If you consider the maturing of the legal landscape, certainly. Perhaps then back to you, George. Just in the event, now you've managed to convince the creditors, or you need to keep them confident in the business rescue proceedings. And as a business rescue practitioner, perhaps on creditors, which are important, but another tough question in the business rescue proceedings is employees. And how would you go about managing those expectations of those stakeholders specifically?
Yes, excellent question, Brandon. I've also practiced as a liquidator lawyer, but more at that stage for approximately 10 years as a liquidator. And then you are a destructor of jobs. When you get to the liquidator's instruction, statutory instruction is to collect the assets, sell the assets, and divide the income so derived in terms of a certain set of rules. And that is not the instruction of a business rescue practitioner. The business rescue practitioner's instruction is to provide for an efficient rescue and recovery of a financially distressed company in a manner that balances the rights and interest of all relevant stakeholders. I'm reading out of the Act Section 7K. We rely on heavily. So if you start to balance those rights, and the Labour Relations Act is paramount to the Companies Act, then you can befriend the workforce very quickly, because your aim is to save the company that's providing them with jobs, and their aim is to keep their jobs. So it's aligned. Sometimes they don't understand you, and you have to explain yourself properly. And sometimes if you haven't got the money to pay the salaries in month end or wages at weekend, then it's a problem. But I find that the employees are actually the most easy creditor or affected person. Affected persons are now creditors, shareholders, and employee or employee representative bodies like unions. But I find that they are more friendly towards the process than anybody else, I must admit.
Oh, thanks for that, George. Certainly surprising, but I know I've had conversations with you in the past where you've had quite good support from trade unions, in fact, of the plan, which is actually a very positive development. Just switching to the question, and I mean I posed it earlier, but we've got when we talk turnaround, you've got pre-business rescue. you've got business rescue and then liquidation. And often one of the reasons that creditors would want to pursue liquidation is that it holds better mechanisms for dealing with fraud, arguably. So, for example, you got your Section 417 inquiries where you can investigate the dealings and affairs of the company, and liquidators are afforded quite wide powers in that regard. So, I mean, I'd like to maybe get Lizelle, your view on perhaps, you know, the business rescue mechanisms, and how does one deal with fraud in business rescue, maybe in light of comparing it to the liquidation scene.
Brandon, first and foremost, I think there's in this industry, I think there's a lot of people who said this before me, so it's not my words, but business rescue is a forward-looking process. Liquidation is a backward-looking process. What I mean by that is liquidation is exactly what George has said. Liquidator is appointed, there's a concursus, there's a line in the sand. All that he or she needs to do is collect and preserve the assets, realize it, and make sure that there's a distribution in accordance with the Act. Business rescue is first and foremost to ensure that the company could potentially proceed as a going concern in a solvent basis again. If that not, then you move on to the secondary leg and purpose of it. That being the case, there is certainly good writings on this to suggest that the moment that you deal with fraud, which you still need to uncover and understand, business rescue is probably not the process for that company. You should probably rather in that scenario and situation go on to a liquidation. That being said, of course, the business rescue practitioner, in terms of the Act, does have he's got the duty to investigate, but he doesn't necessarily have the power to do anything. So all that the Act says in business rescue, you have to, as the BRP, you need to investigate. If you see anything, you've got an obligation to report it to the NDPP, and you have to instruct management to take certain steps to the extent to recover, etc., etc. That is as far as his role goes. Why? Because he's got one job to do, and that is to actually try and restructure the affairs, finances, and move forward. So yes, there are abilities to consider and to investigate, but I would say at the risk of being quoted, if it is to such an extent that it's so entrenched with fraud that you should probably in any event put an end to it just from a public interest perspective, wipe it out, get to the bottom of it, and close down the company. If it's one director who's committed the fraud, you investigate it, you report it, and you probably just get rid of them and move on. So it depends. There are remedies available for both, but it depends on which side of the spectrum that company sits at the time when you investigate and uncover the fraud.
Thanks, Lizelle. And George, I'd go back to you. What steps would you take as a BRP when you uncover fraud within the entity?
So as Lizelle said, it's a forward-looking process. And, you know, I've mentioned that I've been in liquidation situations before. And I would say in the liquidation situation where you get a big company under your control, you usually try to sell the business as a going concern, and a little bit of trading takes place and so on. So then you save the soul of the business, but you still have got the mechanisms of Section 417 and others available. The question that arises is if you uncover fraud in the company, then you still have to balance the thoughts that you can save some jobs. You know, it's very, very important in my context, and I think in the South African context, that we save jobs, that we save businesses that employ people. And we have got a fiduciary duty as business rescue practitioners to report it to the National Prosecuting Authority and you know, for investigations. but the Act states if there is the business rescue practitioner conclude that there is evidence of a fraud, then you have to do so. So the word evidence and the conclusion is very important. I try to follow my fiduciary duties, but seriously, I weigh it up to the advantages to go through with the business rescue. And I don't say forget and forgive, but because it can be big fraud, and there's nothing like small fraud and big fraud, but you have to weigh this up. But the statutory instruction to you is to report it to the authorities.
Right, thank you for that, George. Essentially, fraud, perhaps, it is so that the liquidation mechanisms are better suited for fraud, but uncovering it in business rescue doesn't automatically assume that that's the best that scenario to follow. If I understand you correctly, your obligations remain balanced interests, like as you mentioned, Section 7K of all affected persons, and see if you can rescue that company.
Yes.
Right. So, Lizelle, back to you, and we're talking about managing the business rescue process. Oftentimes we hear, and not just in business rescue, but for the purpose of this discussion, certainly, affected persons, particularly creditors, might feel aggrieved by the way the process is going, the way the business rescue practitioner is handling the process, and what sort of remedies are available in those scenarios when we talk about removing a practitioner, for instance.
Brandon, before we get maybe to what remedies are available, I have to maybe just point this out. There's a difference between someone just being aggrieved and disgruntled, in particular in the context of a business rescue. It's not an easy process. I understand, in particular from a creditor's perspective, you've been dragged by the nose and you've been told and promised that you're going to get paid, and all of a sudden you are not, and there is a business rescue and you're not allowed to sue, and all of a sudden you immediately feel you're on the back foot, which I accept and I appreciate. But there's a very big difference and between someone just being disgruntled versus raising a true and honest grievance, which will lead to a legal remedy being available. There are legal remedies. One of them that you've mentioned is that to remove a BRP. There is instances and there are matters in court currently running where creditors, companies, investors, etc., are pursuing business rescue practitioners in their personal capacity. All of that are remedies available to creditors. Not to discourage them to follow those, but they are not easy. It entails court processes, and it is an expensive process. I would, and this is probably where my wearing my advocate's hat or my legal hat comes in. It's also sometimes for me depends on the advice and the legal advice that a creditor gets. More often than not, you'll see through proper communication and transparency, you can perhaps bridge that dismay or impasse. If not, of course, you can go and you can apply for the removal. That's probably your first step as a creditor. If you again, it depends on the situation, because if it's just a lack of communication and which I can understand is probably what ticks off most people, most creditors or affected persons most. But to get to a point where you have to actually then move the practitioner without properly trying at least first to engage and communicate and get to the bottom of it, might just frustrate the creditor more. So yes, the remedies are available. One of the other remedies that I may want to mention is also simply that's why the regulators and organizations are there. That's why you have CIPC. That's why you have BRPs that need to have some designation at a recognized organization such as SAQA, SARIPA, TMA. All those places and organizations have their own disciplinary processes as well, which a creditor can, or any affected person or interested party can, of course, follow.
No, thanks, Lizelle. I think that's quite a pertinent point. In liquidation, business rescue, it's unlikely that a creditor is not going to be disgruntled. But that being said, I think I noted from the CIPC presentation that we also shared earlier, there's quite a focus by the CIPC on the filing of the Section 132 monthly reports of the BRPs. I mean, it goes to the point of constant communication and openness, just keeping everybody confident and about the process.
Brandon, if I may, I think that's exactly, and one of the key issues, and maybe George can also weigh in here, that was discussed at the summit on Monday, is creditors, and I would dare to say all affected persons, simply want communication and transparency. Again, there are levels to it. We've all been subject to business rescues where the practitioner sends his report every month after the 3 months, and the report absolutely says nothing. The report just resuscitate what has been said, and that continues for wherever. In those circumstances, of course, you can only reach such a point. But so just to communicate is not efficient. It needs to be updated communication. It needs to be transparent communication, because it is sensitive. And I think most practitioners who's at least worth their worth is trying to do exactly that. Not only because they have to, but it assists with the disgruntled and acrimonious communication that may follow.
Well, indeed. And George, if I can bring you back in, I noted from your LinkedIn that you managed to publish a plan within 25 days. Obviously now thinking of the reports, none needed in that scenario. Not often that the plan is published so quickly.
Yeah, the Act states that you have to report to creditors and or to the court if it's a court application with 3 months after your appointment. Fact of the matter is in practice, I had a business rescue in my firm for 9 years, and it was because of a immovable property that I sold, a large immovable property, and the subdivision didn't go through, and we had to litigate against the city of Tshwane to get clearance certificates and to get the subdivision through. In the end of the day, the buyer that bought for 7 million rand way back in 2012 cancelled on us, and that business rescue was then dealt with in another way. And it was after 9 years in business rescue, we gotten to file a substantial implementation notice. So that is an example of nothing to do with the business rescue practitioner, but outside forces that is in a sellout scenario that was now influencing the outcome of the implementation of the business rescue plan. To publish a plan within 25 business days is some type of a world record. We don't know if it will stand the test of time. The company was under financial pressure on a month-to-month basis. The landlords should have been paid, and the employees, and that was why we burned the candle on both sides to publish that plan. We haven't voted on that plan as yet. We will vote on that plan hopefully next Tuesday. But that is uncommon to publish a plan so quickly. Usually it will take you approximately a month or 6 weeks to collect all the information, then another 3-4 weeks to assess the information, get your independent auditors and actuaries and things like to look at the document, and then prepare a business rescue plan. So I would say that 25 days times 2 to 3 is the aggregate of which you will be able to publish a plan. But in the meantime, you have to now trade with the same trade creditors that was disgruntled because you went into business rescue. There is no concursus creditorum or massing of creditors in business rescue, but there is a line in the sand, and there is we're trying to deal with the creditors. Sometimes it's trade creditors, and sometimes it's banks and other creditors. We try to deal with them in a balanced manner. So the situation is that the reporting is one thing. I totally agree with Lizelle's approach. Transparency of the whole process is paramount. The communication, like in a good marriage, if you're communicating with your wife, you cannot tell her that you're going to the golf course every night, but then you go to some other places. But if you're really going to the golf course and you're a professional golfer, she would like you to go to the golf course, So that is transparency and communication with your creditors, high ethical standards, returning of phone calls, returning of emails, and the like. Just proper professional conduct is what the commercial world is expecting from business rescue practitioners.
Thanks, George. I've just got a question for you from Joshua Everly. He asks, do BRPs have an obligation to provide information to creditors that may otherwise be confidential? For instance, if a creditor requests access to financial records, trading records, etc., how does a BRP balance transparency against confidentiality?
Well, Lizelle must weigh in here again. The POPI Act is important. It's a privately owned company. There's a few schools of thought there, but there is, I haven't got it in front of me, but there is a ruling in KZN where Mr. Martins was involved, a lawyer, a business rescue practitioner in Pretoria, where the court ruled in favor that he not need to give the information, specifically the annual financial statements, to a person. There is a section in the Companies Act, earlier in Companies Act, around about section 26, 27, where you can, as a trade union, get the financial information from the company and then bring in a business rescue application. So there is and then it's also where the deputy sheriff has nulla bona return, then there's also a way of getting that annual financial statements to the creditors. But in general, these days with the POPI legislation and other relevant legislation, you have to be very careful. But we must understand, with the necessary consent of all people, that it's easy to hide behind the legislation, but with the necessary consent of everybody involved, you can divulge that information to people. And if you go for a loan or PCF agreement or type of financing at the bank, you have to give that information, because they won't give you the necessary finance if you request for post-commencement finance. So it is a balancing act, but it's always some question if you're in litigation and you think that your opponent just want information to bring a liquidation application against you. Maybe you'll hide a little bit behind the legislation, but the fact of the matter is as it stands, you're not obliged to give that information, except for the exceptions that I just mentioned. I don't know if you agree with that, Lizelle.
Yeah, I do, 100%, and that is the authorities, the recent authorities in KZN confirms that there's a difference. So to answer Joshua, your question is simply, there's no obligation to do so. The only obligation is that what is provided for in the Act, which must be incorporated in a business rescue plan. Sometimes people do take advantage of it, and you can see it mostly in instances where competitors are trading, which for obvious reasons, you even if you wanted to, you're not going to give it. It is a balancing act. That being said, there are instances where redacted versions of certain things can be given. In the spirit of transparency, you may want to issue not necessarily from the actual financial records, but from a BR perspective, you may be able to say, listen, this was the trade last month, this is the trade this month. We still need to publish a plan, but things are looking up, etc., etc. So there are ways of getting the information across, but certainly no obligation as a default position to do so.
Yeah, thanks for that. I know we are heading towards the hour mark on this snapshot, but the last thing I just want to address is the Westcol decision. Lizelle, if I'm not mistaken, you involved there, but essentially, George, let's start off with you. I mean, my understanding of the judgment is PCF creditors cannot vote on a plan. How do you find this has affected the market? Have you struggled to find PCF after this judgment?
I think it's a little bit of a trap. I just want to know what Lizelle's views on this, and if you've got an opposing view. But we were involved in the matter on a professional basis, but that was not the subject of the appeal. But the fact of the matter is we are struggling all over to get post-commencement finance. The loose assets are so tied up in general notarial bonds, special notarial bonds, cession of book debts, and other forms of security, that when we get to the business rescue, there is no free residue to give up as security. It's a seriously difficult situation to obtain post-commencement finance. So, you know, on the one hand, surely we must make it as easy as possible to obtain post-commencement finance. And on the other hand, there's the legal position. And my view is that the legal position is that post-commencement financier cannot vote. It's not a wish list. It's the interpretation of the legislation as it stands, according to my analysis. There could be a change in the Act. There could be this Supreme Court of Appeal that makes a ruling that differs from that. It is just my analysis that the legislation doesn't provide for a post-commencement financer to vote. But that is by saying that it is when you go into a position where you are looking at being a post-commencement financier, you are seriously covered by Section 154 sub 2 that states that only pre-commencement creditors are dealt with in terms of the business rescue plan. We've developed some plans where we define all creditors at pre and post commencement, and we devised plans to compromise post-commencement creditors and so on. But in a clear reading of Section, and I don't want to lecture on the technicalities of the law, but the clear reading of this Section 154 sub 2 is that creditors at the beginning of business rescue proceedings. So, but the post-commencement finance creditor is a person that can say, listen, this is a condition precedent of my loan to you. I'm going to give you 50-odd million rand, but get your plan voted in. And what your plan must say is this, this, and that. And then you've got a veto right. It's much better than a voting right. A veto right is a condition precedent is much stronger than a voting right to influence the outcome of the business rescue. And if the creditors do not vote for the plan, there's always the opportunity to take them to task to say it's an inappropriate vote. That is a quick one, Lizelle. I think I see you look up to your right-hand side. I've got you thinking, I know.
I've spent many nights thinking about this, George, in preparation for the SCA. Brandon, I was involved. I acted for one of the amicus curiae in the appeal. The only place where I do agree with George is George will also remember dinner. I think we all went to the SCA about 10 years ago, and everyone said it was the sentiment that if dinner is, if it stands the way the High Court has ruled, that super preference is actually not super preference, it falls after secured creditors, it's going to be a detrimental effect. Business rescue is going to come to an end, and everyone, it's the end of business rescue, similar to judicial management. Lo and behold, dinner was upheld. The High Court was upheld. Secured creditors made peace with it, and business rescue 10 years later is still alive and kicking. I think there's a similar sentiment in relation to the PCF, to say that I find it very, very strange when the industry tells, or the profession tells me, I as a BRP, I'm incapable of getting PCF if my PCF creditor cannot vote. I mean, it just seems contrived, but that's possibly where my agreement with George ends. We argued, and I argued certainly, and I just didn't just argue it. I think it's correct that the Act provides, when it comes to the voting interest, the Act simply says that the voting interest is calculated by taking into account the amount owed by the company to the creditor at a specific time. That owed, if the Wilson or the Westgold judgment as we know it stands, I say that you have to read in after that definition to say the amount owing to that creditor pre-business rescue, or as at commencement of business rescue. For the interpretation to work, you need to read into the Act. That being said, one of the things that I mentioned, argued as well, is one have to remember that for a PCF creditor to actually have a vote, it's analogy to what I've used, that for you to get onto the business rescue bus and to have a vote, you actually have to have bought a ticket. You have to have put in money, and then that company must owe you the money equivalent to what your voting interest is then going to be. It's not a scenario where the PCF guy or girl or company gets a vote without having put in the money. So it doesn't necessarily follow for me to say you're going to get your PCF and you're going to be super preferent and fine and all of that, but for now I'm ignoring your claim. If you've bought the ticket and you're on the bus, my view is that you get a vote. That being said, the jury is out. We argued in the Supreme Court on the 29th of August. The Supreme Court said at the end of the hearing they are aware of the urgency and all eyes on this judgment, that they will deliver judgment as soon as possible. It was an urgent, expedited hearing in the Supreme Court, so they are aware of that. So hopefully in weeks to come, George and I can have this debate again, because I think there's no middle way. One of us are going to be right and one of us are going to be wrong. But yeah, we'll see what comes out.
So, Lizelle, if I could just a short reaction. I'm now not trying to be the Supreme Court of Appeal judge, being sarcastic, but your argument is then that the post-commencement financier have a vote.
Yes.
Okay. I was just a little bit confused when you said that they're at a certain stage. But in any case, we totally different, have different opinions. So and I've argued this on a open forum before. I don't say that I am 100% correct. I think there's a need for it, but I look at the legislation and interpretation thereof. But we will have that answer ready at our next webinar, Brandon, shortly before the end of the year, I think. Thank you.
Thanks. Thank you to both of you. At the very least, the SCA will provide us all with some clarity soon enough. And then we can see who was right and who was wrong. Yeah, so thanks to everybody for joining. Thank you to our speakers, Lizelle and George. I don't see any further questions in the Q&A. So from my side, that would be it.
Thank you, Brandon. Thank you, everyone. Have a lovely evening.
No, thank you. Let's see. All the best for till the end of the year. Thanks a lot, Brandon, for arranging this. Thank you, Lizelle.
Thanks, George. Bye, everyone.
Cheers. Bye-bye. Bye-bye.